Hi, in this video we're going to review Florida's statute section 501-171, Florida's data breach notification statute. And we're going to use the 4 criteria that we discussed concerning notification breaches in our last video. So the first question we must ask ourselves is, under what circumstances must a notification be made in Florida? Now, notice must be given to each individual in the state of Florida whose personal information was, or that the company reasonably believed to have been accessed as a result of a breach. Personal information includes an individual's first name, or initial and last name in combination with any of the following: Social Security number, driver's license number, passport number, military ID, or any other similar number issued by a government that is used to verify identity. Credit or financial account numbers. Any information about an individual's health history. Any information about an individual's health history. An individual's health insurance policy number. A username or password in combination with a security question and answer that would permit access to an online account. Public information and encrypted information are exempted from notice requirements. If the breach will not result in identity theft, notice is also exempted. But, of course, that is based on the company's determination. Now, a covered entity refers to the entity or company that acquires, maintains, stores, or uses personal information. The second question we have to ask ourselves in reviewing this notification statute is, what is the required content of the notification to individuals? A covered entity or company must give notice to each individual in the state whose personal information was or was believed to have been accessed as a result of a breach. Notice must be expeditious and without unreasonable delay, but no later than 30 days after the determination of a breach. But law enforcement may delay the notice of the breach for their own purposes. The notice must include the date or estimated date of the breach, a description of the personal information at issue, and contact information for the covered entity or company so that the consumer may inquire about the security breach. Notice must be by one of the following: written notice to the individual's address in the company's records, notice to the email address in the company's records, substitute notice if the cost of the notice would exceed $250,000 because the affected number of individuals exceeds 500,000 persons, or because the company does not have an email or mailing address for the affected individuals. Substitute notice shall be on the company's website, and notice shall also be given to print and broadcast media. The third question we have to ask concerning the statute is, under what circumstances must the company give notice to government regulators and credit bureaus? Notice to credit bureaus must occur if more than 1,000 individuals at a single time require notice. Notice to the state of Florida is made or is mandated if a breach affects 500 or more individuals in the state of Florida, and that this notice must be given no later than 30 days after the breach is discovered. Now, the fourth question we have to ask is, under this statute, what penalties exist? Penalties and litigation exposure if the companies fail to comply with the statute. Companies that violate the statute shall be liable for a civil penalty not to exceed $500,000. It will be calculated as follows. $1,000 for each day up to the first 30 days following a violation. And after that, $50,000 for each subsequent 30-day period or portion up to 180 days. If the violation continues past 180 days, the penalty can then max to $500,000. So there are significant penalties to companies that fail to notify consumers and the state of Florida about data security breaches. Well, I hope this helps. Have a good day.